bit from talking about sexual assault trials generally to jurors' use of a specific piece of evidence. So today I'll be talking about some research we've been conducting to try and understand how we can support jurors to make legally accurate or legally correct decisions using victim intoxication evidence in sexual assault trials. Now the research that I'll be talking about today speaks specifically to complaints of rape made by female victims against male perpetrators. Okay, so alcohol is actually relatively commonly involved in rape cases. So we know that it's particularly common for victims to report having consumed alcohol prior to being assaulted. So up to 63% of victims say that they consumed some alcohol prior to being assaulted by a perpetrator. Now, that means that victim intoxication evidence is something that's relatively common in trials, but the way that jurors are required to use victim intoxication evidence at law can actually be very complicated. So in a number of jurisdictions, and when I say a number, I'm mostly speaking about Australian criminal law jurisdictions and also the UK here, there are three requirements, or three facts, if you like, that the jury have to find in order to return a verdict for rape. So the first of these is that there was sex that took place between the perpetrator and the victim, that the victim did not consent to that sexual interaction, and then the third element is often a perpetrator mens rea element. So it might be a requirement, for example, that the perpetrator intended to have sex without consent. Now, consent is commonly defined as being freely and voluntarily given by somebody who has the cognitive capacity to provide consent. So I've got two definitions up on the slide here for you, one from the UK Sexual Offences Act and one from the Queensland Criminal Code as an example. Now, depending on the submissions made by the prosecution to the jury might be required to use victim intoxication evidence to determine whether the complainant had the capacity to consent. Now, of course, if a complainant doesn't have the capacity to consent, there can be no consent, and so there's no consent via no capacity. So it seems to be the case that in some instances at least, jurors will be required to use victim intoxication evidence to determine whether a victim had the cognitive capacity to provide consent. But what we don't know is if jurors make these decisions and if those decisions are ultimately implicated in the way jurors reach their verdict in rape cases, because research hasn't actually looked at that. But there is an extensive amount of research out there about victim intoxication evidence and how that influences decisions. So I'll talk a little bit about what we know and then where we're going to in trying to support jurors to make more legally accurate decisions. So previous research on victim intoxication and how that influences jury decision making has mostly focused on understanding how it changes evaluations of victims and also ultimately influences decisions that jurors make about perpetrator guilt. So victim intoxication evidence has been presented in a number of formats. It's sometimes been presented as the blood alcohol level of the victim. It's sometimes presented as the number of drinks the victim consumed. Sometimes a subjective description of intoxication is used. So that might be, for example, testimony from the victim saying, I felt really drunk, which I know sounds a little silly, but that's often how it's been manipulated. Or it might be a behavioural description. So in a case synopsis, you might have another witness saying she was staggering all over the place and she was slurring her words and was obviously affected by alcohol. Now, most of this research suggests that when a victim has consumed alcohol or is perceived to be intoxicated, the perpetrator is perceived as much less likely to be guilty of rape. So I think it's a useful exercise to understand why it is that victim intoxication evidence might be influencing jurors' decisions this way, so we can then move forward to how do we help them make more legally accurate decisions. So one explanation for how jurors approach decision making in criminal trials is, of course, the story model. So the story model suggests that basically jurors will create a story for the case events based on their cognitive schema for events. So in a rape case, jurors' cognitive schemas for rape and consensual sex might be at play. Now you heard earlier from Alex that a cognitive schema is basically a script for how we think events happen. So it just tells us how we think these events are most likely to happen. Now, if we look at the common features of alcohol-involved sexual assaults, the most common form of alcohol-involved sexual assaults involve a victim who voluntarily consumes alcohol. So they often will go out with a group of friends, they'll purchase their own drinks and choose to drink them. They're not being pressured or influenced or coerced in any way. and then they'll later be assaulted by somebody who's known to them. And quite often it's an acquaintance or a friend or someone, an ex-partner, someone they've dated, are dating. So those are the two common features, I guess, of these assaults. Now, if we think about how those two common features of these assaults map onto people's schemas, it's actually a very good fit for people's consensual sex schemas. So if jurors are relying on a consensual sex schema to create a story about the case, it's easy to see how they might perceive the perpetrator to be less guilty, because that consensual sex schema will be telling them that it's likely that consent was present in that interaction. So jurors' reliance on schemas to help them organise case information and interpret case information might kind of be leading them to make a decision based on victim intoxication evidence to infer whether consent was present or absent. But at law, of course, this is not what they're meant to do. So how can we help the jury to make a decision about the victim's capacity to consent using victim intoxication evidence? So this is something that's hotly contested because judges and prosecutors are very concerned about how jurors are relying on victim intoxication evidence in rape trials. So in our research, we decided to try and look at two ways that we can support the jury to make these decisions. So the first thing we wanted to look at was the presentation format of the evidence. So earlier I talked about the ways that victim intoxication evidence has been presented in previous research and our understanding of how it influences decisions based on those manipulations. Now, the issue with the way that the evidence has previously been presented to mock jurors is that it doesn't speak directly to the complainant's capacity to consent. So for example, telling somebody that the complainant had 6 drinks isn't a really good indicator of how their cognitive capacity was affected. So I'm sure we all know people who have 1 drink and seem to be quite affected by alcohol, and other people who have a few drinks and seem to be fine. So the issue is that alcohol can affect people very differently. So simply telling the jury that kind of information doesn't really help them to make a decision about how the complainant was impaired. Now, what we wanted to do was try and present a less ambiguous form of intoxication evidence, and this is something that prosecutors already do. So what we decided we would do is we would have the prosecutor in the case actually question the complainant about how alcohol had affected them. And our aim in doing this was we thought that perhaps if we gave more direct information about how alcohol had affected the victim's capacity, the biasing effect of the presence of that alcohol evidence might be reduced. So the other thing that is quite often discussed as a way to support jurors in these cases is, of course, the instructions that the judge provides to the jury. Now, there is a lot of discussion about what judges should be saying to juries about how to use victim intoxication evidence to determine capacity. And this was actually the issue that came before the Court of Criminal Appeal in the UK in the case of the Crown and Brie. Now, in the case of Brie, we had a very, a good example, I guess, not good positive, but a very typical example of how alcohol-involved assaults happen. So the complainant in this case was referred to as a woman, she was referred to as M in the appeal judgment. Basically, she went out with a group of friends. She voluntarily consumed alcohol while she was out, so she bought her own drinks, consumed a number of drinks, and by the end of the evening, the evidence was that she was quite badly affected by drink. Now, Brie, who was the defendant in the case, who was amongst this group of friends, actually helped her home. When she arrived home, she was actually physically ill because of the alcohol she consumed. He came inside, helped her clean up, and helped actually put her into bed. Now, M's evidence was that later on in the evening, Brie sexually assaulted her. Now, on appeal, the issue was that the directions that the trial judge had given to the jury about using the intoxication evidence to determine capacity were problematic. And so the Court of Appeal had to decide what should be said to jurors in these cases to support them to make decisions, to help them make decisions about capacity to consent. And after a discussion about the difficulty of providing these kinds of instructions, the Court of Appeal came up with 2 pieces of advice that they felt should be provided to juries by the judge. So the first is pretty simple. It's that alcohol does influence somebody's capacity to consent to sex. Pretty straightforward. The other piece of advice they provided was that at some point prior to becoming unconscious as a result of the alcohol consumed, a complainant can lose the capacity to consent. And the Court of Appeal said that the challenge for the jury in these cases was that at some point, after beginning to consume alcohol, but prior to becoming unconscious, which is quite a big band of I guess, behaviours and experiences that they could be hearing about, the jury had to decide when a complainant had lost the ability to consent, the cognitive capacity to provide consent. So in our research, what we were interested in is whether those instructions that were provided by the Court of Appeal in Brie, and also changing the evidence format of intoxication evidence, could effectively assist jurors to make decisions about capacity to consent. So to do this, we ran a study that used scenarios, and we developed a case that had all of those common features of alcohol-involved assaults. So we had a victim who voluntarily consumed alcohol, and she was assaulted by an acquaintance of hers after a night out. Now, in the case synopsis, we had a transcript of evidence that depicted the prosecutor's examination in chief of the complainant, so their questioning of the complainant. And we had the prosecutor ask the complainant, the victim, about how they were cognitively impacted as a result of the alcohol they consumed. So we had the victim depicted, describe themselves, I should say, as either mildly intoxicated or highly intoxicated. So when the victim was mildly intoxicated, she described herself as having the cognitive and behavioural impairments associated with a blood alcohol level of 0.05, so just good to drive still, maybe. And the type of impairment she was describing was things like feeling euphoric and really social, feeling very happy, but also some more reduced inhibitions. Now, when the complainant described herself as being highly intoxicated, she described herself as having the cognitive and physical impairments associated with a blood alcohol level of 0.10. And the reason that we selected that is because it's typically a blood alcohol level that you would have if you'd been out binge drinking, which of course is a drinking pattern that's regularly practiced in the 18 to 25 age group. Now, when the complainant was depicting us or describing herself as having those impairments, she was saying things like she was slurring her speech, she was having difficulty following conversation, she was having difficulty making decisions, she was having difficulty actually balancing. At one point in the description, she falls out of her chair, so she's quite badly affected by alcohol. Now, after we had the participants read either one of these cases, or case synopses I should say, we gave them an instruction. So in the standard instruction condition, all they received is the information about the rape offence and also a definition of consent. And in the capacity instruction condition, they received that same information plus the guidance that the Court of Appeal had decided in the case of Brie. And then after participants had read this case scenario as well as the instruction, we asked them a series of questions. So we asked them about how likely it was that the perpetrator was guilty. We also asked them to evaluate the complainant's capacity to consent. And we also asked them how similar the events were to typical sex and also typical rape. And the reason that we did that was we wanted to get a sense of whether jurors might be relying on a consensual sex schema or a rape schema to make their decision or make evaluations about the case at the very least. So we had two hypotheses, and what we were expecting in terms of participants' evaluations of the victim's capacity to consent was that when they read about a highly intoxicated victim, the capacity direction would result in them perceiving that victim to have a lower capacity to consent compared to the standard direction. And we weren't really expecting too much to happen in the mild intoxication condition. Similarly for guilt, or likelihood of guilt I should say, we're expecting that when participants read about a highly intoxicated victim, when they receive the capacity direction, they should perceive the perpetrator to be more guilty, because if the complainant doesn't have the capacity to consent, then it should be more likely that the perpetrator is guilty of that offence. And that's of course compared to the standard direction. Again, we weren't expecting too much to happen in the mild intoxication condition. So our participants for this study were 212 jury eligible people, and they were recruited from the undergraduate research pool at UQ. So they were Australian citizens and they were all over 18 years of age. We had a pretty equal split of men and women in the sample, and the age range of the sample was 18 to 47 years, but you can see the mean age was quite low, so it's about 21. Now, what did we find? So the first thing we looked at was the participants' perceptions of capacity to consent. Now, oh, my red box is missing, so I'll have to talk you through this, I'm sorry. So The blue bars here are the mildly intoxicated victim, and the red bars represent the data for the highly intoxicated victim. And what we got was an interaction of level of intoxication and instruction type. So for the highly intoxicated victim, what we found positively is that the capacity instruction was actually operating as expected. So when participants received a capacity instruction, they perceived the highly intoxicated victim to have less capacity than when they received the standard instruction. So this is mostly good news. It's particularly good news for the juror guidance provided by the Court of Appeal, because that particular instruction has been highly criticised, and it's been criticised on the basis that it doesn't provide enough information for jurors to actually shift their decision making, and this data would suggest that the instruction does do what it's meant to be doing. So that's some good news. So the next thing we did was we had a look at perceptions of the perpetrator's likelihood to be guilty of sexual assault or rape. And we actually found no effects based on either level of intoxication or direction type. Now this is a little perplexing, because one thing that's definitely come out of prior research is that the intoxication level should have an effect on decisions about guilt, and that's a pretty consistent finding. So this was a little bit perplexing to us as to why it's not coming out. Now you can see that the highly intoxicated victim condition, where jurors read about capacity, had the capacity instruction, seems to be moving, and it's trending in the direction expected. So they're perceiving the perpetrator to be more guilty in that condition, but it wasn't statistically significant. So the next thing we did was we started to have a think about what could be influencing the decision about guilt. And what we were interested in is whether there might be an indirect relationship between victim intoxication and perceptions of perpetrator guilt. So here I've got some zero order correlations of basically whether decisions about the victim's capacity to consent, and also decisions about whether the events are similar to consensual sex or rape, are correlated with the likelihood that the perpetrator is guilty. And what we can see is that all three are significantly correlated in slightly different directions, of course. But it looks like the rape schema, rather perplexingly, is the most strongly correlated with decisions about the likelihood of guilt. And if I haven't bored you too much at this point, you'll remember that earlier I said that we thought it was probably a consensual sex script that jurors might be using to make decisions in these kinds of cases. But what's important about this is that the consensual sex typicality and also the rape typicality are intercorrelated. So I'll explain why that's important in just a moment. Okay, so we decided we'd run a serial mediation analysis to try and understand what the relationship was between victim intoxication and the decision about the likelihood of the perpetrator being guilty. Now, originally when we ran this model, we actually ran it with both the consensual sex schema and the rape schema included in parallel in this model, and the rape schema dropped out. So there was no relationship between the rape schema and the likelihood of guilt. So for the sake of simplicity, I'll just present the model with the consensual sex schema included. So what this tells us is that there's basically, the more the victim is intoxicated, the more the victim is depicted as intoxicated, the less capacity they are perceived to have to provide consent. But the more they're perceived to have the capacity to consent, the more similar the events are to consensual sex, and the less likely it is that the perpetrator is guilty. Now, there's some good news and some bad news here. So the good news is that decisions about capacity to consent do seem to be involved in jurors' decision making about guilt, which is positive because it suggests that jurors are doing what they're meant to be doing according to the law. The problematic element here is the reliance on a consensual sex schema also to make the decision. And the issue with that is that if jurors are relying on their schema, we have a strong preference for relying on our schemas. So it could be that that schema is overcoming evidence that might be presented in the case to suggest that consent was not present. The issue there, of course, is that the schema might be true in some cases and it may not be true in others. So it's a source of extra legal bias that might be creeping into the decision making here. So what's the take-home message? Well, the positive part here is that instructions, or those instructions that were suggested by the Court of Appeal in Brie, do seem to be assisting jurors to make legally correct decisions. The bad news is that there's still a reliance on consensual sex schema to determine guilt in these cases. And like I said, that can be a source of extra legal bias, so it's still a bit of an issue. And that's